One divorce I worked with, it involved I believe it was a salon, a hair cutting salon. And the business was owned by husband, wife, and wife's mom. Wife's mom owned 50%. How do you divide the business then? Who gets what interest then? It was a challenge. And obviously, we weren't dividing up a business, but we were dividing the values and the interests and ultimately buying out husband so that wife and her mom could own it together. And lots of different negotiations had to happen to make that happen. And to also figure out what was husband's actual portion, how much was his portion worth, and how much was going to be portable for him to another salon. It's complicated, and you do have to look at these pre-existing agreements because the court can't affect the rights in that particular case of wife's mother. The court could only impact the rights of husband and wife. So now that brings me to the third type, operating agreements. If it is not a solely owned business, if either husband and wife own it together, or wife and wife, or husband and husband, or one of them owns it with a third party or multiple third parties, once again, you cannot impinge on the rights of those third parties in a divorce.